JP, you're muted.
Well, that's a good start. All right. As people pour in, I thought I'd go ahead and start. So welcome to the Child Protection Advocacy Section's monthly Lunch and Learn webinar. I'd like to appreciate and say thank you from the Executive Committee to Jerry Bruce and Diana Johnson for participating and presenting today. I want to share with everyone that the CLE is pending approval, and hopefully that approval will be forthcoming. And I appreciate your time today. There is a Q&A and a chat function, and I hope you'll take advantage of that. And because this is a short lunch, I'm going to turn it on over to Jerry Bruce and Diana Johnson. I want to introduce Jerry Bruce is the Director of the Office of Child Advocate, and Diana Johnson is the new effective, I think, July? August 1st of the Court Improvement Program. And I appreciate their knowledge and expertise to bring to this great conversation during lunch. Thank you so much.
Thank you, JP. So I'll just say to start with that well, there's a question already. This is great. Oh, and it's already being answered by Lane. Thank you, Lane. About the materials. The CLE is pending, so they can't send the materials out until the CLEs are approved. So no, the check is in the mail, as we say. So these are some topics that come up again and again. I actually made the outline, so I'm responsible for kind of the general flow of things, but it's very loose. And if y'all have specific questions other than where are the materials, please put them into the chat box or the Q&A and ask those. I think we're both pretty comfortable just winging it and answering your questions as they come along. But we do have a sort of rough outline that I put together because it's the sorts of questions that I see come up again and again and again and again. And so wanted to kind of address some of those things. One of the first areas I think it's useful to talk about is an area that both I know that Diana and I both have a real interest in, and that's the effective use of evidence and the adversary system in dependency cases, because we have a lot of practitioners and even some judges who don't really have a background in trial work and are maybe uncomfortable with not only with the techniques of trial work, how do you do those things, but also with the philosophy of, well, why should we be doing trial work like this? Why should we be practicing an adversarial system when we're really just trying to find out what's best for kids? So I have a friend who's a judge who, when he first got on the bench, I was still on the bench at that point, and he called me up and he said, I really just want to get down off the bench. I want to turn the tape recorder off. I want to sit around a table and I want to have productive conversations about what we can do with the cases. And I said, well, that's really a really good idea, but it's not what the juvenile code envisions in terms of how to handle these kinds of cases, because the state usually has taken someone's child away and impinged upon their constitutional liberty interest and family integrity. And the state has a burden of proof at all of these hearings, and the burden of proof never changes from the state. And it's difficult to move a burden of proof, a needle on a burden of proof when you're having conversations and you're not making a record and people aren't really objecting and they're not vigorously defending their positions because they believe that they're supposed to be really sort of nice around the table. And the great thing about the adversarial system is it's a really good way to effectively weigh competing versions of reality, which is what we have when we come to court, unless everybody stipulates and you don't need a hearing, in which case that's great. But usually there's some discrepancies, there's some disagreement on major or minor issues, and sometimes on both. And without an effective use of the adversary system, usually the person with the loudest voice in the room wins. And that's not an effective way to determine what's best for kids or families, or to determine what really happened in cases. So, I think we'd love to get people feeling more comfortable with the idea that the effective use of the adversary system cross-examining witnesses. I know some attorneys have said to me, I'm really uncomfortable cross-examining witnesses. I feel like the judge gets impatient when I cross-examine witnesses. But again, if you're not cross-examining the witness, then the only version of facts that's coming out is the version of facts from the proponent of that witness. That's usually the government. And you don't want the government's version of facts, if there are material differences, to be the only one that the court hears. It doesn't make sense to do it that way, to allow the government to strategize everybody's case for them. So that's sort of a general introduction to the idea of why the adversarial system is really useful. Diana, you have anything you want to add there?
Yes, I hear all the time from judges and attorneys that we should not be using the adversarial system. We should all be cooperating and negotiating and it should be friendlier because we're dealing with children and we're dealing with families. And my reaction to that is actually the exact opposite. I find that when a court is not employing or allowing that adversarial system, what hearings turn into is basically it is almost as if we're all sitting in the judge's living room having a discussion, but one party, usually the SAG, is controlling the flow of information. And that's not productive because in order to make good decisions about children and families, the judges need every bit of relevant information in front of them. The other thing about the adversarial system is people think about trauma. We are dealing with children and parents who have been traumatized. And one of the most, as a person who spent, a decade representing parents mostly, one of the most traumatic things for a parent in these court hearings is to feel like they are sitting there while a bunch of people are having a discussion about them without including them. And one way that I have found effective in reducing my clients' trauma in the courtroom is if we're in that proper adversarial system. And, we've all been there. Your client's freaking out. That person's on the stand lying about me or whatever it is. And it's much easier to say to the client, we're all taking turns. It's Jerry's turn to put up his case, his witnesses, and say what he wants. Then it's this other party's turn, and then it's our turn. We will have our say. You will have a chance to have your position represented. And that takes away a lot of the trauma of court, even though, you wouldn't think that the adversarial system would be the most appropriate system for traumatized people.
Yeah, I think those are really great points. It's, a lot of the dissatisfaction with outcomes is not so much that parties feel like they didn't win, but that they didn't get heard. And then that's not just that they didn't get up on the stand and testify, as Diana says, that their version of facts didn't come out. It's not in the mix. The court's not considering it. So it's really important from a procedural and sort of philosophical justice standpoint to have all of these things in the mix. And the best way we know of to test the reliability is through that vigorous and appropriate cross-examination of witnesses called by other parties. You can find out amazing things when you really appropriately know your case and cross-examine witnesses on the things that they say on direct that sound so certain and so clear, sort of often fall apart, or at least seem less certain and less clear when cross-examination is used. So it's merely a matter of testing the water. And people that hear me present are probably sick of hearing me say this, but I always liken it to, like the testing that goes into the making of car designs. Cars and airplanes, modes of travel are tested far beyond what they're normally going to experience in daily use, so that when you trust yourself and your family to those modes of transportation, that they're reliable, right? So all the adversarial system is a system to assess reliability. So it's a stress test, basically. And that's really all it is. And that makes it a very important thing, because the decisions that courts make in these cases have profound and long-lasting impacts on children and families that appear in front of them, and sometimes on third parties as well. And so we want to make sure that the information received by the court that goes into that calculation but findings of fact and conclusions of law is the most reliable evidence the court can have. So one of the things that come up again and again, and remember too, please, if things we say bring up questions that you have, please put them in the chat boxes. And I'm sort of moving around a little bit on my outline, Diana, but is documentation. Because, you know, in juvenile court, we deal with a boatload of documents. We have, you know, psychological assessments. We have Casa reports. We have, I hope we have those. We should have reports from the attorney's GAL, although we often don't. And we have other types of assessments, reports, drug test results. I mean, we have all kinds of documents that we have to deal with. And it's amazing when you go and watch court and you hear people, first off, the biggest problem that I think we have in Georgia across all of our jurisdictions is that people, even in review hearings, this is not acceptable, is to talk about a document, the contents of a document that has not been tendered and admitted into evidence, right? So the contents of a document that have not been tendered and admitted into evidence are irrelevant, legally speaking. So if you have a document of any kind, even if it's a prior court order, that needs to be appropriately put before the court in the context of this hearing today and admitted into evidence by whatever standard governs the introduction of that kind of document, so that now it's part of the record and now we can talk about it. Now we can assess the reliability of the things within it. And so documents just tend to get talked about across the state without actually getting introduced. And one of the most common documents that gets talked about without being introduced is the case plan. I was talking to an attorney guarding ad litem about a case that my office is investigating last week. And I said, you know, I've looked through the entire court file in this case. This case has been going on for almost 2 years, and I can't find a case plan. And she said, oh, we never do that. And I said, what, abide by the law? You don't abide by the law? And she said, well, we don't do that. I mean, the judge makes findings and puts things into orders, but we don't have written case plans. And I said, well, if you don't have a written case plan, you don't have a case plan, right? Because the statute says that the agency has to produce a written case plan and propose it to the court in a formal method so that everybody gets an opportunity to look at it and have input on it, because it's the roadmap of the case. You know, it's the strategy of how you want to get to the permanency option that's appropriate in that case. And most times that's reunification. And it's impossible to strategize the roadmap if you don't have the roadmap, right? And then they're required to get that order, that case plans incorporated in a court order so that it becomes something that's operational, that has validity and legal effect, and that can be talked about. So, you know, I just want to put out a plea there. I know a lot of you are thinking, what? No case plans, that never happens, but it really does. All across the state, we have hearings and we have cases where case plans never get produced and they never get incorporated into a court order. And parents are not bound by case plans, families and children aren't bound by case plans that don't exist in the court record and that haven't been incorporated into a court order. And that also means that those case plans drive the conversation at review hearings about how are things going, right? Are we giving the right services to people? I mean, we don't start from scratch every single time we go into a review hearing, and review hearings are 90% of what we do in juvenile court. We have the evidence of the prior case plan that's already been incorporated. And a lot of what we do at review hearings is look at the contents of the case plan and assess not only all the parties, the state and everybody else's compliance with the case plan, but also its continued appropriateness, right? Do we need these services? Are there services we don't need? Are there services we're not getting that we need to add? Is the outcome, the permanency plan, appropriate? Things like that. So documents, really important. And Casa reports are writings. There's just no way to deal with our evidence code and come away with the idea that a Casa report, a written report by a Casa, can be considered by the court until it has been tendered and entered into evidence.
I will add that there was a case back in, it was 2018, and I'll post the site, I'll post the citation in the chat, where the department was asking for non-reunification based on case plan non-compliance. And the case was appealed. There were multiple other problems in the case, but the Court of Appeals made a pretty big deal about the fact that in reviewing the record, although the case had been going on for several years, there was not a court-ordered case plan in the file. And in fact, I think it was like the day before the non-reunification hearing was when defects finally filed a written case, and the Court of Appeals said that that was not acceptable.
We have some questions in the chat about saying my county does that. I assume that means does that, like has no case plan or something like that. What authority can I cite to? And someone else says we have the same question. So the case that Diana just referenced is something that we can put up as well. And in general, of course, when you're dealing with case plans, you're dealing with Part 10 of Article 3, you're dealing with 1511, 200 through 204 as your most primary statutory framework for the fact that we have to have a written case plan, and it has to be brought before the court. The court has to incorporate that in an order. And when you take that together with the case that Diana cited, you can find that as well. And we've had termination cases overturned on appeal because there were no case plans in the court record. And of course, that's one of the big questions of termination is the compliance with the court-ordered case plan. No court-ordered case plans, no issues of compliance. So I hope that helps. And if you have continued questions about that, let us know. A lot of people ask about the Casa reports. You know, if the Casas aren't lawyers, how do you get those Casa reports in? And normally I think the best way to do that is either to have a sort of standing practice in the court that you've discussed with the court beforehand of having the court ask, here's the Casa report, and we're going to call it Court's Exhibit 1. Does anybody have any objection to it coming in so we can talk about the contents of this report? And then it becomes part of the record because it's a statutorily required report. It doesn't exempt it from having to be brought in appropriately and put in the record. So that's an important thing. Diana, you want to talk about drug test results for a minute? Because we have a lot of drug test results, and Diana has an enormous amount of expertise regarding drug tests. And we're in the middle of kind of a roadshow about drug tests that Diana and Dariska and I are doing. And you know, the state relies on drug tests, courts rely on drug tests repeatedly. And it touches on this because every drug test has some kind of result, visible result, often written, that we have to figure out a way to come before the court. And you read a lot of appellate cases where the court seems to scratch its collective head because the transcript says that the case manager gets up and says, oh yeah, we gave mom 3 drug screens and she failed them all. Things like that. You want to talk about that, Diana?
Sure. I'll actually talk about the whether or not it's competent evidence. I'll let you talk about the evidentiary challenges of the actual results. So this is sort of a preview to the drug testing CLE that Jerry and I have been giving. We did it at NACC in Denver in August, and we're doing another one on the web in November. So, and I can also post those slides. Basically, I have become increasingly disturbed about the use of drug tests to make major decisions in juvenile court. And one of those reasons is we have this practice where someone shows up to a parent's home or workplace, or the parent comes to the defense office, or the parent gets sent somewhere in the courthouse to take a drug test. And those drug tests are, they're called point of care tests because you take the test and you get the result. And the courts tend to put an awful lot of weight on the results of those drug tests. But in looking into it further, what I found is if you go back to the drug test itself, there's a package insert in there for every single one of these tests because it's an FDA regulated product. And the biggest piece of information in that package insert is that these tests are that results should be considered preliminary only, that they are not completely reliable, and that they need to be confirmed by further lab tests. And too often in court, what we see is either, hey, we know, the mother just tested positive, or we'll get a little, sometimes Xerox copy of the drug test itself with a little checkbox thing that says, marijuana check, cocaine check, and major decisions in a case are made based on those tests that are inherently unreliable. So I'll let Jerry talk a little bit about putting up that fight against that kind of unreliable evidence.
Yeah, so this brings up a really important distinction that a lot of practitioners miss between hearsay and best evidence and proper foundation. Because first off, if you have a writing, let's say, a drug test, and a case manager says, mom took a drug test and it was positive for cocaine. A lot of people would say hearsay, that can't come in, but then you're in a review hearing and hearsay comes in. And so you might feel powerless to do anything about it. But talking about the results of the drug test are not really a hearsay problem. What they are, when you're talking about the contents of a writing, you're not really talking about hearsay unless the writing quotes somebody or summarizes somebody's statements, basically. When you're talking about the contents of a writing, you're talking about best evidence. And the best evidence of the contents of a writing is the writing itself. That's the best evidence rule that is incorporated still in our 2013 evidence code. And so the appropriate objection is best evidence. The case manager's testimony about the contents of this writing is not a hearsay issue, it's a best evidence issue. We have to have the writing so that we can, again, think about reliability, right? We don't have to take the case manager's word for what the writing says. We need to have the writing itself. And the writing itself might have all kinds of information in it that would allow you to test the reliability of the case manager's assertions on that or any other question regarding that the contents of the writing. So when you're just dealing with the contents of a writing, you're dealing more with a best evidence issue than you are with a hearsay issue. And so even in a review hearing where hearsay is admissible, the best evidence rule is not abrogated. So the Court of Appeals told us in the CH case, the citation of which I'll put up, which came up in the context of a review hearing, that the juvenile code requires that the rules of evidence be followed even in those kinds of hearings. So even though hearsay may not be admissible, may be admissible over an objection, the other rules of evidence still apply. So you're dealing with an appropriate best evidence rule. And then if that report comes in and is admitted, and we can then talk about what happens to it, what the contents of it mean, we have another foundational issue, because those reports are scientific reports and they rely on the application of expertise to a set of processes. And without an appropriate foundation, the Daubert and Kumho tire questions that come under our evidence codes section on expert witnesses, without that, there's not an appropriate foundation to consider the reliability of the actual test itself, not just the document, what the document says, but the underlying test results that are now memorialized in this document. And parties have a right to inquire into whether or not those with scientific knowledge and expertise or any other kind of technical knowledge and expertise have been properly qualified to make that kind of expert opinion, to come to such an expert opinion, and B, whether their background, training, and experience have led them to have sufficient basis for those experts' opinions, and whether they have done the things that have to be done to reach this scientific or technical result, if they've done those things correctly, and whether everything was working correctly. So again, those aren't hearsay issues, those are proper foundation issues. And so you shouldn't roll over and play dead on the question of drug tests specifically, because those come in a lot. But this is true of psychological evaluations and of parenting assessments and bonding assessments. All of these things require the application of some type of formal expertise to a set of processes to come up with a result which has to be subjected to the reliability tests that are set forth in our expert witness, expert testimony statute. So I would encourage everybody to do that. So we have a question that says, you're saying that the department needs a lab expert in order to admit any drug screen at any hearing. Well, it depends on the kind of drug screen. Certainly the person who conducted that screen, whether it's a urine screen or and this is the thing I can never say, and Diana always helps me with this, the gas
chromatography mass spectrometry.
Gas chromatography mass spectrometry. I don't know why I have such a difficulty with this. That kind of thing. You've got to be able to produce the person who did that, unless the parties stipulate all those questions under the expert testimony. We know this guy. Parties may have reasons, sometimes strategic reasons, not to object to the introduction of such evidence. Maybe it's favorable to them. Maybe it helps something else down the road. Maybe there are strategic reasons to do that. But normally, parties have the right to inquire into whether any result of scientific or technical expertise is properly done. That's what that whole expert testimony set of statutes under our evidence code are for. So that's really important. So yes, I'm saying that the department needs some type of witness to testify to whether or not the drug screen was properly conducted, whether that person was properly trained. For like a urine screen, that may be a relatively low bar, right? What's the requirement? How do you get trained to do this? How do we know you did this right? How do we know you maintained the sample correctly and that you read it right? What did it look like? Do you still have it? Let's look at it now. Let's see what's going on. And as Diana points out, in the evidence in the drug screening seminar we do, have you looked at the instructions in the manufacturer's pamphlets about the appropriate use of a urine screen? Are you aware that the instructions probably say that this result is not dispositive and can't be used to support a conclusion that the person who took this used any particular drug, that it's only a threshold test? I mean, those are all really important questions, and you would never know those things if you just allow someone to say, yeah, mom took 3 urine screens and she was positive for all of them. It's a whole wealth of information that's not coming before the court dealing with reliability. So dealing with state contracted drug testing, one of the chat box comments says, whom do you call to testify, explaining the testing process, including the procedure of collecting the samples and its transmittal to the testing lab? Well, first off, if you're not the state, if you're not the government, you don't have to call anybody. It's the burden is on the proponent of that test to provide the appropriate witness to support it. So, if you have an objection, you say, well, objection foundation, I need to talk to the expert. The expert's not there, then you're going to have to wait. The expert's going to have to be brought. That's something you're going to have to work out. If you're the state, then you're going to need to at least find out whether the parties are going to object to that information beforehand by providing copies of the results in advance of the hearing and letting everybody know. I mean, that's just something that's appropriate professional courtesy, and then finding out whether we need to have a witness brought in to be able to answer those questions or not. And then it's who is formally responsible for reaching that opinion. Expert witnesses can rely upon the work of other people, as long, again, as they do that appropriately. You have to bring every single person who was involved in the testing, unless you have a chain of custody question, which you might well. Anyone who's practiced criminal law knows that the integrity of a sample, whether that's urine or some sort of mysterious white powder or whatever, depends a lot on how it's handled and stored between the time and the proper method by which it's collected so that it's not contaminated. And so that we know that we're talking about this white sample that came from this person's possession is the same thing that was tested by the lab, right? There's all kinds of opportunities for slip-ups, loss, and confusion between the collection of a sample and its final testing. And so you've got to have those chain of custody lay out that chain of custody, and counsel should ask those questions. But as far as the expert testimony goes, the expert can rely upon even the inadmissible work of other people in reaching that testimony. So you've got to have the person who comes up ultimately with the opinion. Do you want to add something, Diana?
No, I was going to add that we only have an hour, so we need to get out of the drug testing rabbit hole.
Yeah, let's get out of the drug testing thing could take up the entire time, and I think Diane and I are both happy to talk about it the whole time. But I did have a question about case plans. Is it enough to state the case plan is hereby made an order of the court without formally making it an actual exhibit if the case plan goals were stated on the record and the parent agrees? So the statute requires that DFACS produce a written thing called the case plan. That case plan has to be introduced and brought into court so that it can be discussed and made part of the record. What the statute says is that it has to be made a discrete part of the record. So it has to be there. So whether that's by the court saying, is there any objection to my making the requirements of this case plan the requirements of the court, the order of the court, and incorporating it now, or whether, as many courts do, there's a supplemental order incorporating a case plan that follows the hearing itself. Either way, as long as that written case plan makes it into the record and it is clear that after having had opportunity to object by the parties, the court makes that a discrete part of the record, because that is what the statute requires. We also have a question about copies of the case plan being given to the parent. The question is that my county says the SAG sending me the copy when submitted to the court service of the case plan on the parent. So that's an interesting question. If you're counsel for the parent and another party serves a document on you, they've served it on the parent. I mean, that's just the way the law works. You're a proxy for your client, except for certain things, like some things that require personal service. That's not the same thing. But for the service of most items and documents and other things that happen in the course of a case going, if you're the lawyer of record for that person, then giving it to you is giving it to your client, whether that's a notice of hearing or something else. So that's a real important thing to keep in mind. It's also important to remember that the state is required to give portions of the case plan that deal with the child and any services provided to the child to the foster parent. And that's something that almost never happens.
I'll add that as a best practice, although if I remember correctly, I used to give the parent a copy of the case plan myself. But in addition to that, I also sit down with the parent, and we've all seen case plans. They're horrible. I mean, they're so hard to read, and we're lawyers. So what I do is I would sit down with my parent client and distill that case plan down to a checklist so that they know exactly what they're expected to do. And then as our attorney-client relationship progresses, we are going back and referring to that checklist because I'm following up. Hey, did the psychologist call you? Did you schedule that appointment? How far into parenting classes are you? And those things, which is really hard to do with a 15, 20 page case plan that really only has about 2 or 3 relevant pages in it.
Okay, so we've got a lot of questions coming up on this. And some of these we may have to answer after the fact because of our time constraints. We only have about 20 minutes left. One question from Judge Scales is the significance of the parent signing the case plan or not signing the case plan. I've heard that actually become like the source of some real controversy in hearings. I never signed that. I never had anything to do with its development or something like that. So what the code requires is that DFACS develop the case plan in consultation with the parents and any child who's 14 years of age or older. It doesn't mean that those parties have veto power over what goes into the case plan, but the case plan should memorialize the positions of the different parties so that it shows, if they don't agree, so that it shows that this process, the statutory process, was included. But in the end, the case plan is a recommendation by DFACS to the court of both a permanency plan and certain services to be offered. The case plan has to be developed usually prior to, so for instance, the first review hearing, because it's required to be developed by the state 30 days from the date of removal, right? 30 days from the date of removal. So it's definitely, unless there are tons of continuances, it's going to be developed prior to, say, the first 75-day case plan, the 75-day review hearing. So this is a recommendation by DFACS. It's going to have to be altered by relevant evidence that comes up at any hearing later, but it is DFACS' recommendation. It doesn't matter whether the parent signs it. There's no statutory requirement that a parent or a child sign the case plan. What that signature line in the form is actually supposed to memorialize is that it was developed in consultation with and discussed with the parent and a child who's 14 years of age or older. It doesn't signify, shouldn't anyway, and I haven't looked at the language in a while, and it's been changed a little bit. I don't think it signifies consent. I don't think it says, the parent consents to this case plan or anything like that. Since there's no requirement that a parent sign it that's in the statute, I'd probably be wary about having a client sign the case plan in case there was an argument that it did signify consent, because it's not required. It's a DFACS recommendation to the court, and then you'll talk about it in court, and the court either makes changes to it or doesn't and incorporates it in a court order directly or indirectly. So
I'll add that anytime a client signs a case plan, because attorneys are never allowed in those meetings where the case plan is developed. Even if the client signs the case plan, it was done not in consultation with the client's attorney, and that document itself, as Jerry pointed out, signed or not, is meaningless until it is adopted as an order of the court. So whether the client's signature is on it or not, I don't think carries any significance.
We have a Q&A on an interesting question that takes us off in a little bit different direction, which is the requirement of 1511-112B that there is a presumption that visitation be unsupervised. And the Q&A question is, I'm in a court that defaults to supervised visitation in every case, despite those provisions. And the attorney says, I'm told I have to request a hearing in order to ask for unsupervised visitation, but the court will always generally finds supervised visitation is required. Your thoughts on that, Diana?
That's not what the law says. And a lot of times, and I know that we get into these courts, we get into these practices with the same judges and the same people over and over, and that we develop and perpetuate a lot of really bad habits. And you are going to be the least popular person in the courtroom if you just keep bringing this up, but you have to, because you need to try to force compliance with the law. And if you can't do that, you need to set yourself up for a good time.
There should be an active conversation in every single case. The law requires courts to default to unsupervised visitation and to find cause to depart from that in order to implement supervised visitation. So the burden is on the proponent of supervised visits. It's not on the court. The court doesn't have a position, right, with regard to any possible outcome in the case. Initially, the court relies on the evidence presented by the parties. If the government doesn't provide sufficient evidence at the hearing to show that visitation should be supervised, then it's got to be unsupervised. Obviously, if the court finds some issue that's been raised in the development of the evidence in the case and wants to inquire into it, but again, the burden is on the state to show that that visitation should be supervised rather than unsupervised. And the burden of proof on any issue in a dependency case never shifts to the parent. I mean, you may have a burden of persuasion issue, but you never have a shifting of the burden of proof. And we do this all the time, right? We say, well, dad couldn't provide me with proof of income, right? Well, I'm sorry, but dad's under no obligation to provide proof of anything any more than he would be in a criminal case. And it's the same kind of thing with visitation. right? There's no requirement that the parent demonstrate during the production of evidence that they deserve unsupervised visitation. They get unsupervised visitation unless the state demonstrates a compelling reason to move to unsupervised visitation. This should be a real conversation that's had each and every time a disposition hearing comes up, whether it's incorporated in the adjudicatory hearing or whether it's later on. And of course, disposition is an aspect at every review hearing and permanency hearing. So basically, almost every time we come to court, we should always be having active conversations about family time and about how to increase it and make it better, and whether or not the state has actually proven the need for supervised visitation. So there's no default to supervised visitation. It's quite the contrary. So we have a couple other questions. And JP's putting up some of the bench cards in the chat, which is extremely useful. And Judge Hurd points out that the parent's signature is supposed to establish that the parent receives a copy of the case plan. We hope that's true. I mean, I've had cases where parents have signed the case plan and have never received a copy. But that is apparently the rationale for the signature line, is that it's a sort of service, question of service. We provided it to them. If that's the case, then we need to include in the state form a place for the foster parent to sign showing that they've received their copy, a case for the child who's 14 and older to sign. There may be one for the child actually there, I can't recall, but there's not one for the foster parent. There ought to be a line then for everybody who has a statutory right to have all or part of the case plan. And that's something that should be inquired into if it's not clear from the face of the case plan. So we have a question about where would you recommend that an attorney serving as a stated interest child's attorney seek more guidance or training on working with and the ethics of child representation in this capacity as a directed interest lawyer? I've always been familiar with dual GAL and stated interest representation, and I'm struggling with drawing boundaries. So I'll start out on this because I'll tell you, and this is only my opinion. This may not be Diana's opinion or the opinion of the CIP or the opinion of anybody else. But I believe that there is a deep and unresolvable structural conflict with the dual appointment, right? So you will say to me wisely, the Court of Appeals has looked at this, Jerry, already, right? And they've already said there's no structural conflict. But the question presented to the Court of Appeals was on just the stated duties, right? There's no inherent problem with the different stated duties unless a conflict arises, right? Great, I got that. I can read those things. The problem is, and the question that the Court of Appeals has never been asked to look at, and that I think is an unresolvable dilemma, is that if you're the attorney for someone, everything that person says to you, except in very limited circumstances under the rules of professional conduct, is absolutely privileged. It's not just confidential, it's privileged. You can't talk about it. You can't summarize it without the client's express permission, all right? If you're the guardian ad litem of a child, 1511, 104, 105, all of those sections on the GAL require you to share the information gained from the child with all kinds of other people, with the court, with the other parties. You're supposed to share that information. You're supposed to communicate the child's wishes and desires, and also things that the child may have told you that argue against the child's wishes, right? Because you're not there to inform the court just what the child's wishes are, but what the entire sort of universe of facts that affect the child are. And there is no way to resolve that conflict. If you're a child and you ask your duly appointed lawyer /GAL, are the things I say to you confidential or not? It's impossible to answer that question. So I think that there's no way to properly do those, because you can't communicate anything as the GAL to the court if you're also the child's client. So you can't do the GAL. You can have the dual appointment, but you can't actually do any of the GAL stuff. So what's the use in creating dual appointments? I know they're there because the statute allows it, but at the time, no one asked this question. And we should ask this question, right? How can you, are the things the client tells you confidential or not? But if you're just the stated interest attorney, then our code says, our juvenile code says you follow the bar rules insofar as you can do that given the age and developmental level of your child client, which means that just like with any other client, you have a duty to counsel and to talk about ramifications of decisions. But in the end, if your client asks you to do something that's stupid and you believe that you've presented all of the other options and the client actually understands the ramifications of doing something stupid, you got to go in there and ask the court to do the stupid thing. So you owe that child, as much as possible, given the child's age and developmental level, the duties that any attorney owes to a client.
That there's also a lot of confusion because we have a statute under which the court can remove a GAL for not doing their job. But when you have a dual role attorney GAL, the court and anyone else is completely blockaded because of the privilege that comes along with being the attorney from invading that attorney-client relationship to ask relevant questions about, for instance, why the GAL is making this recommendation or what that attorney has done to fulfill their duty as a GAL. So it creates a cloud that it obfuscates a lot of information that would be very useful to the court to know.
Exactly. So somebody please appeal that and let's get this resolved one way or the other so that so I can shut up about it. But there's a common question. I mean, people ask this question all the time. We have some more questions coming up. I'm just kind of scrolling through to make sure that I'm not missing any of them. They're popping up in both chat and Q&A, so I'm sorry if we don't get to everything in our time. JP's pointed out that our stated time is supposed to run to 1:30, so I guess we have a little more time than we expected, right? JP, you'll jump in if I'm like misreading that, right?
Correct.
I wanted to talk about non-reunification for a minute because I read, and I see this a lot, but I mentioned an investigation my office is doing, and I read the case record, and the second to most recent court order in that record says the court finds that reunification is not in the best interest of the child and hereby imposes a non-reunification case plan. So let's just get straight, right? There is no such thing as a non-reunification case plan. Please don't let your judge say that. And if your judge does say that, please, you can point out, I know you didn't mean that, judge, because we all know let's clarify. There is no non-reunification case plan, right? Our case plan, our permanency plans are reunification, permanent guardianship, and adoption, or APLA in some cases. Those are our approved permanency plans. We do have a dispositional alternative that's also not an approved permanency plan for direct grant of custody to a party. So that's an effective permanency plan, even though it's not a federally or state recognized permanency plan. It is a dispositional alternative, and I think that's just because of an oversight. It looks like the legislative intention is to make that grant of custody a permanency plan. So those are the permanency plans. So non-reunification just means that reunification isn't the permanency plan anymore, right? So please don't wind up in a case with a non-reunification case plan or permanency plan, right? All that means is we're not going to provide reunification services anymore. And also remember the requirement that the court has to, the finding of fact and the conclusion of law that the court has to make, rather, regarding non-reunification is that the provision of reunification services will be detrimental to the child. It's actually a pretty high bar. It's not just, I don't think this is working out, right? But there has to be specific evidence that the court can rely on to find that reunification should cease. And if you do a search of the appellate cases on Westlaw or LexisNexis or something like that, and you put in juvenile court and non-reunification, you'll see cases pop up again and again and again where we're reminded that non-reunification determination is really extraordinary. There have to be compelling facts in the case there's statutory, obviously there's statutory groundwork for it if there's aggravated circumstances, but beyond that, there have to be some really compelling facts for support of finding that the provision of reunification services is detrimental to the child. So if you get there, then the next question is, well, what's the reunification? What's the permanency plan now? It's not reunification anymore. What is it? Is it going to be guardianship, permanent guardianship? Is it going to be adoption? Is it going to be APLA? We hope not. Is it going to be a direct grant of custody to somebody? So remember to have that discussion if you get to that non-reunification determination. And you can get to it sometimes without a lot of advanced warning, because there's two ways to get to that. DFACs can request, they can submit to the court a revised case plan that does not recommend reunification, in which case the court has to call a hearing. The parties have to be served with that motion essentially for non-reunification, and then there has to be a hearing. But the Court of Appeals has also told us that the legislative intent of our statute on non-reunification is that a court can find sua sponte in the course of any hearing that it is detrimental to the child to further pursue reunification and enter a non-reunification finding. So that can kind of come up without a lot of warning sometimes. So just prepare to move on to the next question. Well, what's the permanency plan going to be now if we're not going to be reunified?
I will point out, and I'll put the citation in the chat, that there was a 2018 case in which the Court of Appeals said that the court may find that reunification efforts are detrimental when uncertainty about the child's future living arrangements is harmful to the child. So that bar of showing harm isn't as high as you might think it is for non-reunification.
What the Court of Appeals says is that there has to be a clear, logical reasoning that the court demonstrates, and that because reunification is the preferred first permanency plan. So I think maybe compelling reasons is too, because compelling reasons has a statutory meaning, so I probably shouldn't use that. But there has to be sufficient evidence for the court to find that. Yeah. So it can be based on the facts of the case. It could be based on housing, as long as the court can tie that to why it's detrimental to the child to go forward. So we had a question from the host asking whether we would discuss whether service on an attorney is lawful service.
So anything that's not covered.
A little bit.
So anything that is not covered in the juvenile code is, we fill in the gaps with the civil practice. So where personal service is required, service on an attorney is not acceptable. However, when you're talking about the service of motions in an ongoing case, things like that don't require personal service, service on the attorney is actually the proper way to serve a client, to serve a party.
And that's it exactly. And service causes a lot of problems for us on the appellate level. And it's funny because service is like, the foundation of the house. And so we have attorneys, these are SAGs because they're the ones building the case mostly, who build the house without the foundation, right? Service, when service is required, is an element of proof. And the state has the burden of proving by clear and convincing evidence that whatever service is required by the statute was provided in that case, right? Obviously, if you're a movant, then under the Civil Practice Act, you have a duty to serve the other parties with your motion. But as far as most of the, most of our petitions for adjudication and termination of parental rights go, those are generally generated by the state, and the state has the burden at the hearing that comes out of that, whether that's an adjudication or a termination hearing, to prove by clear and convincing evidence that the requirements for service were met. And you see a lot of cases where nobody talks about service. And service, of course, when it's personal service, is going to generate a document. And now you're back to that question. We have a document. We're not going to talk about this document until it's been properly introduced. So we need a summons and a certificate of service, a sheriff's entry of service, or something that substitutes for that in an appropriate case, made part of the record so that it's clear, because we're not going to talk about the contents of a writing without the writing. And if the writing says, I served mom on this date, then we're not going to talk about that without the writing because it's a violation of the best evidence rule. And we just forget to serve people sometimes. And the area that we mostly get tripped up on is service by publication. And the areas in which we tend to get tripped up on service by publication are first and foremost that parties forget to go to the court and get an order from the court that's based on either testimony or an appropriate affidavit showing that the party seeking service by publication has exhausted all the other statutory methods of service first, has tried those or knows reasons why they're just not applicable in these cases. And then and only then can they ask for service by publication. So that's where we get tripped up a lot. Either they don't go ask, or they do go ask and there's no record made of it, because when the Court of Appeals looks to see if service by publication was appropriate, they're looking for that on the record conversation, that affidavit showing the efforts to provide alternative service first, to provide preferred service first, and the unavailability of those, the diligent efforts of the proponent of that service argument to have exhausted all of those before going to service by publication. So we get tripped up on that kind of thing a lot. It's also important to note, because I had a case where I was dealing with this recently, where personal service of a petition became an issue a couple of years down the road. Case had been going on, and there was an allegation made by the state, which was kind of surprising. Oh, we never personally served the mother in this case, so we are without jurisdiction to actually continue. Judge, we need to wrap this case up and send the child home. And as much as I'm a real big fan of reunification, that's a faulty legal argument, because it's clear under the Civil Practice Act that even where personal service is required by the statute, it can be waived in a number of ways. And one of the ways it can be waived is by never objecting to, these are parents who had come to hearings. If you come to hearings, then you have actual notice, right? There's no issue of service. And if you show up and you don't make any objection to personal service, then you waive personal service in those cases. So you can waive even statutorily required defects in service as long as they don't deprive the court of subject matter jurisdiction.
So from going back to that in the interest of BG case, service was actually an issue in that case because the child was in the custody of two relatives, and one of the relatives had not been served. And the state tried to say, oh, well, this guy keeps showing up to court, he knew what he was supposed to do. And so the service issue came back because he was never properly a party to the case. And it's not properly a party to the case, you certainly can't require him to do a case plan and win a non-reunification against him. There's a citation I'll put in the chat in the interest of RC. That was a case in 2017 where an entire TPR was overturned because the mother had been inappropriately served. I believe she'd been served by publication, but there was not the appropriate affidavit in an order for publication.
Yeah, obviously you can't waiver doesn't become an issue in service by publication cases, because those are cases where there's nobody around, right? There has to be some indication that they've actually are aware of the proceedings. So that's important. We get tripped up on those a lot. So Diana, we've had a couple of folks ask questions about parents who are facing criminal charges and how the disposition of the dependency case affects those and what their stipulations may be to dependency. What do you think about that?
So one of the first things that a parent attorney needs to do when they're dealing with a parent who has corresponding criminal charges is to contact the public defender or private attorney or conflict attorney who's representing that parent, because you may have a lot of dual interests where I could feel really great about myself for working quickly toward reunification, but that reunification is not going to matter. My client's going to prison for 10 years. So there are a lot of considerations that you really need to strategize with the criminal attorney about. There are times when once you've talked it through with the criminal attorney says, don't do anything. Because of the circumstances of the criminal case. I've also had cases, mostly unexplained injuries to infants, where the criminal attorney says, try it, because I'm trying at a lower standard of proof at a time when my client has not even been indicted. That criminal attorney has no subpoena power, has nothing. So what they're getting from me is the sharing of documents that I've subpoenaed, as well as a chance to sit in the courtroom and listen carefully to the witnesses against the client, so that if this case goes to trial in the criminal court, then there's a chance that if that testimony changes, that he can impeach that witness. And also it's a sneak preview that will help with plea negotiations.
Speaking of experts, and not sort of rolling over and playing dead in the face of expert testimony, there is a real live scientific, it's not just a debate, it's kind of a brawl going on right now among scientists about the reliability of what we would normally used to call shaken baby testimony. I prosecuted a lot of these as a SAG, and my witnesses would say, we have these triad of effects from shaken baby, and they can't come about any other way. And for a long time, there was really nothing else on the books there, but now there's a real vigorous scholarly debate that may open up questions of real doubt about the validity and reliability of those cases. So if you're no matter whether you're a SAG, a parent attorney, child attorney, and you're looking at one of those cases, it's really useful to make yourself aware of the broad parameters of that debate. If you're the state, so that you can shore up your expert, and if you're the parent or the child, so that you can ask the court in an appropriate case for a second opinion, for another expert to look at these questions, which is always appropriate if there's a real live question in the scientific communities. You can Google this. There's a ton of stuff on it. The Guardian, the British publication, The Guardian, did an extensive look at the stuff that's free and available online. I just looked at it last week on this question of shaken baby, and that's something where in the past parents just rolled over and gave in because the normal experts called by the government simply said, look, there's no other, and they're still going to say that there's just no other explanation here, and you're hard pressed. How can you argue with that unless you've looked at that? So that's something really important to look at, because that may be something that's in doubt, and the scientific consensus may be changing regarding that. So really interesting stuff for cross-examination there.
I'll add that there are an astounding number of exonerations going on right now. If you read any of those cases, some of it's just horrifying. But as horrifying it is to think about a person spending, decades in jail for something they didn't do, those orders are an amazing look at how to try one of these cases, whether it's an unexplained injury or actual shaken baby syndrome allegation, about the importance of talking of obtaining expert witness testimony, of carefully reviewing medical records. It's a real lesson in how to try these cases.
Here's a good question from the Q&A. What are your thoughts on the status of not having legitimated your child as a ground for dependency? What do you think about that?
So that question brings up a lot of other things, because under our code, if I'm reading things correctly, a biological father who is not legitimated is not party to the case, because he is not considered under Georgia law. Now, what happens in reality is that if that putative father shows up, a lot of times the court will treat him as a party, and defects will offer services to that person, and will, get him legitimated in the course of the in the course of the dependency case. Not legitimating as a cause of dependency doesn't make any sense to me, because, you know, dependency is a child who has been abused or neglected, and not filing a petition in a superior court somewhere to change some paperwork. I can't see how that is a positive. I can't see how that's neglect or abuse.
And of course, the court has the option to grant custody to parties with less connection to the child, to persons with less connection to the child, biological, legal, or otherwise, than the non-legitimated biological father, right? So, you know, that's a real interesting question, and I think it would have to be so fact specific as to how that set of a lack of a court order, as Diana puts it, creates dependency for the child, when the court could give authority to that person to care for the child.
Yeah, we've also got a case, and I don't have the site handy, where the Court of Appeals ruled that the parents of unlegitimated fathers are still grandparents for the purpose of looking at relatives. That the father's legal status does not negatively affect the grandparents' relationship with that child.
I'm just looking through there's a lot of engagement on the chat boxes. What's your opinion about a putative father? We're going to put some twists on this, who is in the U.S. illegally. We see that pretty frequently these days.
Oh, well, I'm not sure what it's in relation to. There was I think that whether or not that person has documented status in the country, I don't think should affect that father's ability to legitimate. There was a case, oh gosh, it's been 10 years ago, and I'll look up the site, that one of the reasons, I think it was a non-reunification case, and one of the reasons for non-reunification was that the father was in the country illegally, so could be deported at any moment. And that case was overturned by the Court of Appeals. But legitimation, there's a best interest finding in legitimation. And I'm sure that same argument could be made, but I don't think that it should happen there.
So we have a question about CPRS. This is great. And JP noted in the chat box that it's the next thing on the agenda. So maybe we can move from some substantive subjects to the question of the court process reporting system, CPRS. So I've been a user of CPRS since 2011, and I love CPRS. It's extremely useful. I don't know if the practice is going to change with Diana at the CIP. I can tell you that when I came to CIP, the practice was that if the court wanted to use CPRS and wanted practitioners to have access to CPRS, then they could have access to CPRS. And I'll get into the specifics about CPRS and how it works in a minute. But my view was that what we really wanted was, again, reliability. We wanted attorneys, GALs, CASAs to have as accurate information as they could about the case, as updated as possible. And so whether or not the court was using it, they could get that information because they're going to be providing it to the court directly or indirectly for purposes of the findings of fact and conclusions of law. So if an attorney wrote to us and said, hey, here's my appointment order in this case, they would have access to CPRS for that case. Judges have access to CPRS in a broader sense. They can see any case in the state. CPRS is a thing that's been going on for more than 15 years, and it's an extremely powerful tool And somebody told me not long ago, hey, if you were just developing CPRS and you were charging a whole bunch of money for it, people would be standing in line and saying, this is great, we can't live without this, we need to buy it. But the fact that it's been around so long and it's free has led a lot of people to kind of neglect it. What it does is CPRS is based on, at the time, it was the first in the country, first of its kind anywhere in the country, of a complete data sharing agreement between the judicial branch of Georgia and the executive branch of Georgia, personified by the Division of Family and Children's Services and DHS, so that every piece of information that wasn't work product or caseworker notes or something like that, that's in SHINES, the state system for tracking DFACS activities. Everything in there about first children in foster care and later even children with family pres cases and things like that. All of that every day goes into CPRS, where it's organized according to the child's name and the county in which the case is found. So if you have a child in a particular county, you can pull up that county, you can pull up that child's name, and you would see everything that's in SHINES at the base level. So this provided a lot of information because you don't have to call the case manager to say, what have you put in your proposed case plan that hasn't been made part of the court record yet? Because you can see the case plan development in CPRS. Where's the child placed? That placement information is in CPRS. Where's the child in school? That's in CPRS. How long has the child been in care? If you're new to the case, you're getting up to speed, there's a roadmap section on CPRS that'll tell you all this information about the life of the case and its procedural posture. And there are now enhancements to that basic information as well, because starting in 2018, DFACS and the Attorney General's office reached an agreement with the CIP that was brokered by then presiding Justice Namias, now Chief Justice Namias, and Attorney General Chris Carr, that requires all SAGs in the state, all DFACS SAGs, to upload a copy of every single stamped, filed, and signed court order into CPRS. That benefits all the parties involved, and it benefits DFACS as well, because DFACS, the state of Georgia, is suffering on 4E reimbursements from lack of court orders, even in cases where the court order had been entered and it just hadn't been properly transmitted to DFACS. We have two-way communication with the SHINE system that DFACS uses, and every night we get the information, CPRS gets the information from DFACS. Any information that's been uploaded into CPRS goes to SHINES and falls into the correct case in SHINES. So they immediately have the uploads. We have some SAGs who are not currently uploading orders. The case I was investigating, I couldn't find the most recent orders in CPRS. The thing to do there is to talk first to the SAG and secondly to the state office at DFACS and say, look, the SAG's not uploading orders as you've directed them to, and they've taken steps in the recent past to make it so that the SAGs start uploading those orders because they benefit everybody. So then you have copies, stamp file copies in PDF format of all of the orders in the case. So really useful information. It has modules that also allow, if the court participates, for the e-signing of court orders, so that you can present a court order to the court by uploading it. The court can review it, the court can e-sign it, and then it's e-filed according to state e-filing certification requirements, and language is put in there to show that it's been properly e-signed and e-filed with reference to the appropriate statutes that allow that. And that makes things move along very quickly. I mean, when I was a judge, I'd be at a conference somewhere and I'd be on CPRS signing orders, and they'd be immediately uploaded to the clerk's office, who would e-file them, and then they were available to everybody. So really useful stuff. The great thing is that CPRS allows you to have up-to-date information about what's going on in the case. And a lot of CASA programs across the state upload their CASA reports to CPRS as well. So you can go in there and find those CASA reports. So these are areas where if you want access to CPRS, I think probably you should just ask for it. I don't know if that policy will change or not, but certainly talk to Diana about it if you want access to CPRS. And if your court is not fully using the capabilities of CPRS, that's a great opportunity for a stakeholder meeting. I've gone all over the state and provided CPRS demos to judges all over the place, and most judges who see CPRS are very happy to really enable its full use in their jurisdictions. So if you need CPRS credentials, then let Diana know, and she can talk with you about how that can happen.
Actually, I just put it in the chat. You just need to email George Lee, and I put his email address in there. Telling him who you are, what your role is, and include your appointment order to that particular case. And he will open up, give you credentials to sign into CPRS, and also open up your access to particular cases.
All right, let's see what else we've got. 14-minute warning given just now by JP. So we've talked about CPRS. It's probably a good place to introduce you to the 4E pilot projects. You think that's a good topic, Diana, to get as we wrap up? So we can talk about those. So most of you are aware that states are eligible to receive reimbursements for foster care, not just court foster care, but their entire child welfare system from the federal government. It's a direct entitlement, and states get millions of dollars back every year from the federal, from the Title 40 of the Social Security Act. And the quid pro quo is that states do several things. They have to enact certain statutes that comply with federal statutes, which is why, unlike say probate law or something like that, outside of criminal law, dependency is the most federalized area of law we have, and why when you can go from state to state to state, you'll find broad areas of commonality in their whatever stands for their juvenile code. What in that state would be the juvenile code in Georgia, because the 4E requirement is that states implement certain things. So for reasonable efforts findings, contrary to the welfare findings, 15 to 22 for TPR, all of these things are in state statutes and the statutes of federally recognized tribes because of 4E money coming in. I mentioned getting docked on 4E for not having court orders. They also look at the quality of our court orders to see that they're not just checkbox orders that don't actually recite actual facts that were found in the case. And one of the other things they do is in the past, you couldn't use 4E money, reimbursement money, to do anything that would affect the outcome of a particular case. But starting 2 years ago, that rule changed because the quality of legal representation in dependency cases has become a hot button topic all across the country. The most common complaint that I hear from judges is that the attorneys practicing before them don't have adequate trial skills or know how to do things properly. So it's quality legal representation. It's become a huge issue all across the country and in Georgia. And now we can claim 4E reimbursement at the state level for money spent ensuring quality legal representation. So what we've done in Georgia is we have the Office of the Child Advocate has contracted with Chatham County to implement our first pilot project in 4E representation. This has a couple of components to it. First, I used to travel around the state a lot, and we would do these best practices seminars, and we'd talk about the stuff we've been talking about now. And attorneys would come up to me afterwards, when nobody else was around, and they'd say, I love all this stuff, but I can't do all this stuff because my judge will get mad at me, and I won't get, I rely on this income, and I'll get taken off the list because I'll be a pest if I'm appealing and always objecting. So what this does is it takes the court out of the mix, and for appointing lawyers, it makes the lawyers truly independent of the court. What's happening we're starting with child attorneys in Chatham County. Chatham County has agreed to hire full-time as county employees 3 attorneys to be full-time, dedicated, directed interest child lawyers. So we've got 1 attorney to appear in each one of the juvenile court judges' courtrooms and to be the child attorney in those cases. Obviously, we have to make provision for conflicts and things like that, but generally, this is going to be the person. And this person is going to be a county employee. and will be completely independent of the court. Not only has Chatham agreed to do that, but Chatham is also hiring office administrative staff, providing office space, and providing a social worker, so that this is a truly multidisciplinary area of representation. The attorney has the ability to consult with a social worker who's working with them on their cases rather than relying on the defects case manager or whatever to strategize their case. So this is a really wonderful thing. The idea is that Chatham County has an interest in providing effective legal representation, and they've really sort of put their money where their mouth is. But B, that right now they're paying a lot of money for attorney representation. There's no quality assurance there. This will have a requirement that these attorneys have pre-service training before they start, and regular and intensive ongoing training and best practices. There'll be court observations to look at the quality of the attorneys. There'll be performance reviews, and we hope it'll really improve the quality and independence of counsel. Secondly, they're spending all this money, they're not getting anything back, and they at least now have the prospect of getting some money back from the federal government in the form of 40 reimbursements if they implement a program of quality legal representation. We've already had other counties say, hey, we want to get in on this too. The long-term blue sky dream is that this will create enough momentum that the state will ultimately, if we have data to show the efficacy of these programs, both in performance, in outcomes, in permanency outcomes and other data, and in money brought down from the federal government to implement a statewide system of child representation and then ultimately parent well. Again, that's a huge long-term prospect. Right now, we're moving county by county, but the goal is to really provide the conditions under which attorneys can have independence, full training, confidence, and courts can know that the people who appear in front of them are provided with quality legal representation. So it's an exciting time to be involved in this. If you're in a county that might be interested in this, please let me know or talk to Diana, and we can get together and work on this, because we're really excited about the prospects of this. We haven't drawn down any 40 money yet because these attorneys haven't started working yet in Chatham County, but they're in the process of hiring them and the office staff and setting it up. So it's a real exciting time to be involved in this work. And I think we'll probably start another pilot project sometime in the first half of calendar year 2022, because we've already got several other counties saying we want to be involved in this. So please let me know if you're aware of this. I think it has a potential to really help improve our outcomes and practice. So we had a sort of ending section on our outline for just open Q&A. People have been pretty openly submitting questions in the Q&A and on the chat. We've got about 5 minutes left. Dan, do you have anything you want to add before we wrap up?
No, I think we've said it all, unless there are specific questions.
I do have a question from JP about the requirements for being a guardian ad litem in juvenile court. So the statutory requirement is that the GAL has to meet the training requirements established by the Office of the Child Advocate. At the moment, the Office of the Child Advocate allows the CASA pre-service training to qualify for CASAs. And remember, CASAs are always guardians ad litem. There's no other role for a CASA under our statute. We know sometimes that judges want the CASA to come in and be the fairy godparent that just sort of flutters around and sort of does some stuff. But the only role for a CASA is as a guardian ad litem, a lay guardian ad litem, and they're bound by those same GAL duties broadly that the attorney GAL is as well. Attorneys GAL have to get the online training from OCA, and that is still online. It's still available. I think I saw someone who said it's not there. I'll check the link afterwards. It should be. It is outdated, but it still qualifies for your pre-service training as a GAL in the juvenile courts of Georgia. We're in the process of redoing that from scratch, and we're putting it up online. It's not free, but if you need to take that and you can't afford it, you let me know, and I'll see that you get a login code that allows you to take it without having to pay for it. It's a really good training because even though it's out of date, it has some pre-testing to assess the person's knowledge of the subject matter. And it's also at the end of every module, there's a subject matter test to make sure that you weren't just checking your email during the whole thing, since it's virtual, and that you've got some substantive information coming in. So we hope that the new version will be available early in 2022. We hope that we'll start filming it early in 2022. We're working with the company that hosts it right now to put the outline together and to bring our speakers together to do that. So that's the pre-service requirement for a GAL to serve in juvenile court. Otherwise, it's 1511, 104, 105 area to find the requirements. And I was a co-author in 2020 of a book of best practices, and that's available, I think, still on the CIP.org website. And I don't think I have access to that anymore, but we can make sure that if it's still up there, that we can put up a link. Sorry about that. My doorbell rang and my dog's working. I'll put up a link to that best practices guide.
And just the last word from me, I'm the evangelist and cheerleader for the Child Welfare Law Specialist certification. And one of the first things I did as CIP director was make an arrangement with NACC that it would allow CIP to pay upfront the application fee for the CWLS certification, so that attorneys and judges don't have to pay that and then seek reimbursement. So if you are interested in that, just drop me an email. I'll put my email in the chat.
And so I think Jerry stepped away. I don't know whose dog. I know it wasn't mine below my table. My old dog is sleeping.
I'm just trying to mute my dog.
And so I will take license, I guess. And so I was going to ask Jerry about the MD Canny and how that can be brought to your jurisdiction as we talk about practices. The MD Canny is a multidisciplinary child abuse and neglect institute. It's trying to get to all different circuits all across the state. If you want more information, it's on the Georgia Court Improvement Project website that has been posted in the chat. For the last 2 minutes, if anyone wants to post in the chat anything concerning any last minute, if not, I will say thanks to our co-presenters, the knowledge, the information, many thanks.
Thank you.
And I will share that next time we'll meet, we have 2 more presentations of Lunch and Learns. Currently, they're tentatively scheduled for a case law update. So hopefully sometime in December or January. We will have our annual meeting, if you remember the section, and we will hopefully have either an evidence or, tough cases involving people, kids who are languishing in care. We're still trying to figure those out. So be on the lookout. If you have any questions on how the child protection advocacy section can come to your area of the state and outside of Atlanta, something that Nikki Vaughn, the prior chairperson, had said that she wanted to do, and I'm hoping we're doing that, which is to bring the section to all parts of the state and not dumping all the resources. If you want to present a project in your area, please send me an email. And if there's nothing else, it's 1:29. I wish you a lovely, safe, and healthy Friday. And take care. Thank you.
This concludes today's webinar. Thank you for joining and have a great afternoon.